A person commits an offense of perjury under Section 37.02 of the Texas Penal Code when he, with intent to deceive and with knowledge of the statement's meaning, makes a false statement under oath or swears to the truth of a false statement previously made, and the statement is required or authorized by law to be made under oath. An offense under this section is a Class A misdemeanor. A person commits an offense of aggravated perjury under Section 37.03 of the Texas Penal Code when the false statement is made during or in connection with an official proceeding and is material. An offense under this section is a felony of the third degree. A couple of things to look at really quickly. Perjury does not cover all false statements giving under oath or during proceedings. There has to be an intent to deceive. And with knowledge of the statement's meaning. So a couple of examples, one being somebody misremembers the day in which he saw the suspect downtown. If he swears under oath that he saw him on a Wednesday and that turns out to be false, if there's no intent to deceive, he would not be prosecuted under the perjury statutes. Another would be with knowledge of the statement's meaning. Someone who is a non-native speaker of English, maybe a prosecutor's question is lost in translation, and they make a false statement. Again, if it's not with the intent to deceive, or they don't understand the statement's meaning that they're giving, they're not applicable to be prosecuted under the perjury statute. Do you want to make note of a false statement versus a literal truth that is designed to deceive? As long as you are telling the truth, your statements are factually true or they're literally true, perjury does not apply. The statement has to be a false statement. So, for example, if the prosecutor misspeaks, he's asking a witness if the defendant had ever admitted committing the crime, but instead of using the word defendant, he uses the word victim. Just a clear misunderstanding. He misspeaks and says, "Did the victim ever tell you that he robbed the store or that he stole the merchandise?" The literal truth to that question would be, no, the victim did not tell me. Even though the witness may be deceiving by answering literally truth, perjury does not apply because it requires a false statement. In those cases, the burden on the prosecutor or the attorney to ask the right question and word it the correct way is his responsibility. That's not on the witness to answer the question you meant to ask. He's answering the question you did ask. Okay. Under aggravated perjury, it elevates the lie or the false statement when it's part of an official proceeding. We generally think of official proceedings as court cases. So in the courtroom, on stand as a witness, during the actual trial or some sort of hearing, could be an administrative hearing, something along those lines. Outside of official proceedings, we might see a police officer filling out an arrest affidavit. There generally would be a statement that you swear under oath that the facts you know them to be true, so forth and so on. So a false statement with the intent to deceive, given that, would fall under perjury. Lying on the stand about what you saw or heard with the intent to deceive would be aggravated perjury. Aggravated perjury only applies, again, during the proceeding if the information or the statement is material. A statement is material if it could have affected the course or the outcome of the official proceeding. So lying about something like your employment status or lying about your wealth, lying about your education, something along those lines, aren't generally prosecuted under aggravated perjury because they don't affect the outcome of the case or the proceeding. When you look at the material statement, whether it is material or not, is generally it's a case of or a question of law, so it will generally be up to a judge to decide whether it is the statement is material or not. Within the materiality section, which is 37.04 of the Texas Penal Code, there is no defense to the prosecution of aggravated perjury if the witness or the person given the statement, in this case, would generally be a witness but could be the defendant and is now a defendant to a criminal charge of aggravated perjury. If he didn't know that the statement was material or mistakenly believed it to be immaterial, that will not be a defense, and he would still be prosecuted under aggravated perjury.